The Aam Aadmi Party and the opposition constantly say that the Supreme Court has said that the Parliament cannot step in here. But remember, and let me just highlight for you how this has essentially played out for the last many years. It started in 2015 when the MHA directed the Lieutenant Governor then to take control over the Services Department. And that means that the appointment of officers, the power and control of that would go away from the Aam Aadmi Party. In 2017, you had, in fact, the central government also taking further steps on that front. It then moved to the Supreme Court in 2018, and since then it's been moving forward in the courts. I want to bring in on this broadcast Member of Parliament from the Rajya Sabha representing the Aam Aadmi Party, Mr. Raghav Chadha, on this broadcast. Raghav, good evening. I'm sure you heard what Home Minister Amit Shah said in Parliament. The most basic argument which the Aam Aadmi Party, which your party has been putting forth constantly, is the fact that the Delhi Ordinance and Services Bill is essentially against legislative competence to bring it in to the Parliament. And this has constantly been countered. Several legal experts here in India today have also raised this, Raghav, saying that it's not true. That, the Supreme Court mentioned that this can be brought up in Parliament. Amit Shah has said that you've kind of misconstrued the Supreme Court order to benefit your argument.
Well, I heard the Honorable Home Minister's comments and his interpretation of a couple of paras of the Constitution bench judgment of the Supreme Court. And I beg to differ with it, and I wish to say that assessment and that understanding is erroneous, to say the least. The Supreme Court in its judgment has said that the centre has powers to legislate on some matters vis-a-vis Delhi, and it can make laws for Delhi. The laws that are to be made have to be within the four corners of the Constitution. They cannot be violative of the Constitution. Just how centre may have powers to make a law vis-a-vis Delhi, but can the centre tomorrow make a law, say, for example, give all powers to the government of Delhi to dictate the foreign policy of India vis-a-vis the United States of America? It can't, because that law, if the centre wishes to enact that law through an ordinance or through a bill, will be violative of the Constitution, because we have a boundary of subjects of administration that has been defined for the Delhi government. Similarly, since they cannot give us a power like the foreign policy, etc., which is beyond the power that the government of Delhi enjoys, they cannot even snatch away a power from us. So they cannot legislate and take away services, that is the transfer posting of bureaucrats, officers, disciplinary proceedings against bureaucrats, etc., from the Delhi government. So therefore, whatever they legislate has to be within the four corners of the Constitution. Since it is not within the four corners of the Constitution, we don't have legislative competence, as in we, the parliamentarians, do not enjoy legislative competence. Number two, it is violative of the Constitution of India. And third, it is a direct and utmost contempt of the Honorable Supreme Court. A Supreme Court on 11th of May 2023 came out with a unanimous 5-judge Constitution bench judgment, which says that services is fairly and squarely with the Chief Minister and elected government. You cannot, after 7 days, come out with an ordinance and take those powers away. And it is a direct challenge of the Supreme Court and challenging the majesty of the Supreme Court. There is no precedent where you can change the Supreme Court judgment without changing the basis of the judgment. And in order to change the basis of the judgment, you have to amend the Constitution, which they are not doing. They are only bringing a simple bill. So therefore, it is unconstitutional.
Raghav, can I read out two parts? One is from the Supreme Court verdict, which says the Legislative Assembly of NCTD has competence over entries. In addition to this, Parliament has legislative competence over all matters by virtue of Article 239AA3A. Now, another point that I want to make here is about also Article 249, which says Parliament should make laws with respect to any matter enumerated in the state list specified in the resolution. The Parliament will make laws for the whole or any part of the territory of India. It's these two parts that Home Minister Amit Shah also has constantly cited.
The judgment that the para that you read out from the Constitution, from the first bit that you read out of the Supreme Court's judgment, that judgment says that in accordance with Article 239AA, subsection 3, clause A, whatever that article that you read out, that article defines the powers of the Delhi government. You cannot add something to it. You cannot subtract something to it. You can only make laws to give effect to that law. For example, can the government tomorrow say that Delhi government will decide on India's foreign policy with the United States? No, because it is violative of Article 239AA. Similarly, they can't take away powers from us also, because that will also be violative of Article 239AA, and that is my short point. And in case you wish to do so, you have to amend the constitution. You cannot do this via amending a bill, amending an act. You have to amend the constitution, which you are not doing because you don't have a two-third majority in the Rajya Sabha. So therefore, this is an unconstitutional act. It is an attempt to hoodwink the Supreme Court, and it will, of course, be thrown in the dustbin because it's not what the paper it is written on once it's before the Supreme Court. Number two, direct abuse of the government's ordinance making powers under Article 123. Ordinances are brought in the rarest of the rare circumstances where situations arise which necessitate an ordinance. There are no situations that necessitate an ordinance vis-a-vis Delhi. There is a Supreme Court judgment giving us all the powers. What was the hurry? What was the tearing hurry? Would heavens have fallen if they would have brought in a bill and not an ordinance? So merely because it is abuse of the ordinance making powers of the government, on that count alone, this bill should be struck down.